revisiting the jurisprudence on capital punishment in India. Well, it is the old Shakespearean dilemma of to be or not to be. And we have arguments, strong arguments from both the sides, which are in favor of capital punishment and also in favor of abolition of capital punishment. This webinar is basically been designed, and there will be a series of webinar coming up from the criminal law cell on the issue of various important issues of criminal law. You may be aware that the Home Ministry has uh, notified its intent that they are going to have a major criminal law reforms. And from a human right perspective, or basically from criminal reform perspective, there are certain important aspects which need to be deliberated. And the outcome of this webinar, maybe the criminal cell, means we are going to work out on that part, would also be communicated to the concerned authorities for this. So this webinar was keeping in mind, calling up expertise on the areas, keeping in mind the point that the government is serious about criminal reforms, and they have National School Delhi is working on it, but also ILS Law College has received the letter, and other major institutions have received letter for suggestions for reform. And we thought that certain important aspects which were always been debated we should speak about. And also this year happens to be the 40 years of Bachchan Singh, wherein the rarest of rare doctrine came up. And let us review what has happened to this whole rarest of rare thing. We have with us eminent speakers, scholars working on this area. We have Mr. Aniket Nikam. He is practicing in Bombay High Court, and he'll be speaking in favor of capital punishment. We have a human rights lawyer, Dr. Colin Gonsalves. Dr. Gonsalves will be speaking in abolition of capital punishment. We have Shreya Rastogi from Project 39A. Shreya will be speaking about the outcomes of the research which they have done. And they have been working on 15 years, the cases in 3 states, trial court cases. This and the outcome of the research what they have. And we also have Advocate Amit Desai, and Amit Desai sir would have a very different viewpoint on capital punishment and the sentencing policy itself. So this is how things would go. A few important notes to be made is that we'll have Amit to start with. Then Colin sir will speak, and after that, because Colin Gonsalves has to leave at 5, we'll open up the house for discussion. You have to put your questions in the chat box, which we'll read up. Colin sir will respond to it. Then after, Shreya will make a presentation, and then Amit will make his presentation. All the presentation maximum time span is of 20 minutes, and then the house will be open for discussion, and then we'll come up with the final conclusions of it. Before we move to the actual sessions of presentation, I request my student Aditi to introduce the guest of today's webinar to all the audience. Over to you, Aditi.
Good afternoon, everybody. I welcome you all on behalf of ILS Criminal Law Cell. Today we have with us 4 speakers. Advocate Aniket Nikam is a graduate of Government Law College, Bombay, and holds a master's degree from New York University School of Law. He is currently practicing in the Bombay High Court and the Supreme Court. Mr. Nikam practices on the criminal side of law. The second speaker we have with us is Dr. Colin Gonsalves, who is a practicing senior advocate at the Supreme Court. He is also the co-founder of Human Rights Law Network. He is known and established lawyer in the fields of human rights law. He has received many honors in the field, and among them, he has also received the prestigious Right Livelihood Award in the year 2007. Next, we have Advocate Shreya Rastogi, who is one of the founding members of Project 39A, which is a criminal justice research and litigation center at National Law University, Delhi. At Project 39A, she heads the death penalty litigation and forensics team. Next, we have with us Mr. Amit Desai, who is a Mumbai-based criminal lawyer with over 3 decades of experience. He is a senior advocate at the Bombay High Court. Owing to his sharp skills and knowledge, Mr. Desai is also known as the stalwart in the field of criminal litigation. I request all the participants to please switch off their camera and audio. I would now introduce our moderator for today, Dr. Nitish Nasagve. He is an assistant professor at ILS Law College, Pune, and research guide at Savitribai Phule, Pune University. Dr. Nasagve also specializes in constitutional law, criminal law, administrative law, and jurisprudence. I would like him to start with the session.
Thank you, Aditi. I made an introduction before, and therefore we have set the framework of the discussion would be that in light of the reforms demanded by the government, and how do you look at this 40 years of Bachchan Singh also, and how do you look at capital punishment and the jurisprudence behind it, and can we come up with few suggestions if there are any? This is what the framework is. I request all the audience except the speakers of the webinar to switch off their cameras and also the microphone. And may I now request Mr. Niket Nikam to come make a presentation, and then after we have Colin sir to speak on. Yeah, over to you, Aniket.
Thank you, Nitish ji. Thank you very much. Let me first take this opportunity to thank ILS Criminal Law Cell for giving us this wonderful opportunity to express our views on that provision of law which has haunted our criminal justice system from past several decades, which is whether India should retain death penalty in its statute books or not. At the outset, let me be very candid. I firmly believe, and I for one firmly believe, that India must retain the provisions of capital punishment. And today, while I speak on this issue, I intend to address on 4 points. Number one, what is the purpose behind the death penalty? Number two, why India as a country has retained capital punishment in its statute books. Number three, the judicial journey of the law relating to death penalty. And lastly, what are the inbuilt safeguards in our criminal justice system in order to rule out the possibility of any error in awarding the death sentence? Friends, when I say that I am in favor of retention of death penalty, my opinion is not based upon any sense of revenge. I am also not banking upon the old and outdated maxim that is tooth for tooth, hand for hand, and life for life. Well, we know for every offense, there is a corresponding sentence provided in our criminal laws. As a student of jurisprudence, we must concentrate on why behind any sentence. Why death penalty to the exclusion of life sentence is certainly a matter of reasoning. And I think that this reasoning has to be confined to the well-established 4 principles of punishment, which we know in our criminal jurisprudence, which are the deterrent purpose, the reformative purpose, the preventive purpose, and the retributive purpose of punishment. Death sentence serves the dual purpose of punishment. That is, it meets the deterrent purpose as well as the retributive purpose behind any sentence. Retributive theory says that we should not lose focus on the mischief that flows from what the criminal has done to his victim and to those who are near and dear to that victim. When we fervently champion the cause of criminals, we should not conveniently ignore the pains and agonies of the victims who are the sufferers of the crimes. I think justice is not only for the criminals, but it is also meant for the victims and the society at large. And that is how the retributive theory tells us that the retributive purpose behind the death penalty is that it gives a sense of closure to the victim or to the family of victim or to the society at large. I'm not much banking upon my argument of upholding the provisions of death sentence in our statute books on the basis of retributive theory. But of course, it is also true that retributive theory is one of the theories or purposes of punishment behind awarding the sentence of death. And we have seen cutting of judgments where Supreme Court has resorted to this theory when it is not as far as personal vengeance, but for meeting the ends of justice. When a crime is extremely abhorrent in nature, that it shocks the collective conscience of the society, then a just punishment is required in such crimes. Well, that is as far as retributive purpose of the punishment is concerned. The another purpose behind a death sentence is that of deterrent theory of punishment. We all know that deterrent punishment acts twofold. Firstly, it acts as a deterrent to that very criminal who is sentenced. And secondly, it is to be a deterrent to the like-minded persons. Now, often, I am aware, it is argued by those who claim for abolition of death penalty that statistically speaking, death sentence does not really deter criminals from committing an offense, that gruesome crimes are still taking place in our country despite capital punishment being awarded to such crimes. And there are statistics that are cited in favor of such argument. Well, when it comes to statistics, what also comes to my mind are the words of Mark Twain from his book Chapters from My Autobiography, where Mark Twain says, and I quote, "There are three kinds of lies: lies, damn lies, and statistics." Well, let me also take this argument head on when it is argued that death sentence is not really deterrent in nature. And if that is the argument, then that argument will stand valid for every kind of punishment that is provided in our penal laws. Even in fact, in the case of murder, the minimum sentence is that of sentence of life. And yet we see murders happening day in and day out in our country. So does it mean that it does not have a deterrent purpose? Does it also mean that we should do away with this purpose of sentence? And in my respectful opinion, it is not so. No matter how dreaded a criminal is, he still cares for his life. He would want to guard his life till his last breath. And therefore, when an accused knows that he would meet the fate of death by hanging, if he commits a crime of this kind, which is of rarest of rare nature, certainly it will be a deterring factor, not just to him, but to all the like-minded persons who would not venture to get into such kind of criminal business. At the same time, I also believe that that sentence can be made more deterring in nature if the entire exercise happens in a time-bound manner. That is, right from the trial court judgment sentencing an accused to death till the disposal of mercy petitions. If all this happens in a fixed time frame, then certainly it will have a more deterring effect. Of course, when I say this, I'm aware that every accused has a constitutional right. That is the right of fair trial. And when I say that the trial must be expedited in such kind of cases, I mean that every protection must be given to the rights of an accused to the fair trial. But at the same time, effort should be made to complete this entire process. Now, Sagri sir, am I audible? Am I clear? Yes. So this is as far as deterrent purpose of the punishment is concerned. Now, let me pause here for a moment. And let me assume, for the sake of argument, that we never had death sentence as a punishment in our legal system in the first place. And let's presume that proposition. We never had death sentence. Then in such a situation, the perpetrators of Nirbhaya, a young paramedical student who was brutally gang raped in our capital city, who was thrown out from a moving bus by her offenders, leaving her there to die. Had there been no death sentence in our country, the death sentence in our statute books, the only punishment that these perpetrators would then have got is that of sentence of life. I am not being bloodthirsty. My argument is not being based upon vengeance. Sentence has a larger purpose to meet. And coming back to that presumption, the offenders of Nirbhaya at the most would have got the sentence of life, which means that our jails would have maintained them while they lived their life behind bars. We would have given them all the medical attention while they were serving the sentence. we would provide them breakfast, lunch, and dinner at the cost of public exchequer. Well, it's a horrifying thought indeed. And in order to avoid this very calamity, our parliament provides death sentence as a punishment to offenders like this. And that is why India has retained death penalty in our statute books. In fact, we all are aware of the fact of the development of law since the event of Nirbhaya. After Nirbhaya, our parliament, which represents the will of Indian people, passed the Criminal Law Amendment Act of 2013, which introduced sweeping changes in the laws relating to sexual offenses. Due to this amendment, now we have section 376E in our penal book, in our Indian Penal Code, which provides death sentence as a punishment for repeat offenders. And the constitutional validity of section 376E was upheld last year by the Honorable Bombay High Court. It will not be out of context to mention here that in the case of Vikram Singh versus Union of India, which is a 2015 Supreme Court judgment, in this case, the Supreme Court was called upon to decide the constitutional validity of section 364A of IPC, which deals with kidnapping for ransom and which provides life or death sentence as its punishment. In this case, interestingly, the Supreme Court held that just because the sentence of death is a possible punishment that may be awarded in a given case will not make it per se inhuman or barbaric. The Supreme Court also observed that the legislature is presumed to be supremely wise and aware of the needs of people and measures that are necessary to meet those needs. Well, at the same time, we are also aware of the fact that when a particular sentence is found to be shockingly disproportionate to the gravity of the offense, our courts have not shied away from correcting the course. When it comes to death sentence, Salmon, the father of our jurisprudence, while considering the propriety and utility of capital punishment, said, "It is better that the snake is out of the world than in it." What was suggested by Salmon is that hardened criminals who are established in courts of law to be beyond corrections and improvements are as poisonous as snakes. Such incorrigible elements are not only cool-hearted and cool-blooded, but they are always and always frozen-hearted and frozen-blooded. In fact, in this context, I am reminded of a Sanskrit couplet, which I think I must quote. Sarpo daunshati kalinah durjanasya pade pade. It means that snake does not bite often, but a durjan, an evil man, will bite at every given opportunity. In this very situation, when it comes to the sentence of death, I equate a durjan with somebody whose guilt of having committed a rarest of rare offense is established beyond shadow of any reasonable doubt, who has not shown any remorse, regret, or repentance in what he has done, who has not shown any possibility of any reformation. For such durjans, in my opinion, law reserves the sentence of capital punishment. At this stage, let me also deal with an argument that is frequently raised by those who say that death sentence should not be there in our statute books. And it is argued that before a man could be sent to gallows, it must be shown and proved that he is a continuing threat to the society, referring to the Bachchan Singh's case. And it is also argued that it is not possible for anybody, or rather it is difficult to show when an accused would still continue to be a continuing threat to the society, and therefore in such a situation, a man should not be sent to gallows. Well, I think Not every accused or a criminal or a convict comes with a baggage. Not every convict has a past criminal record. But in order to decipher whether he will be a continuing threat to the society or not, what is to be seen is the manner in which the offense is committed, the mode in which the execution has taken place, and the conduct of the accused at the time of the offense and after the offense. All these are the factors which indicate whether this particular accused, whether he will continue to be a threat to our society or not. For example, let's take the case of Kassab. When Ajmal Kassab was spraying bullets on innocent people on the railway station of CST at Mumbai, the photographs that were captured of that event showed that Kassab was smiling. He was enjoying what he was doing. Certainly this man was going to be a continuing threat to the society, and in order to show that, it was not necessary that he must have some past criminal record. His conduct was speaking for himself. I think in any debate pertaining to death penalty, it is important also to understand as to how many executions have actually been taken place, or in how many cases a convict is actually executed in our country. And if we see past 20 years, we come to know that Dhananjay Chatterjee, who was convicted for the rape and murder of a minor girl of 14 years old, was hanged in 2004. Ajmal Kassab, the 26/11 perpetrator, was hanged in 2012. Afzal Guru, the man who was convicted for plotting the 2001 attack on our Indian parliament, the man who threatened the very essence of our federal, secular and democratic structure, was hanged in 2013. Yaqub Mehman, the convict in 1993 case, was hanged in 2015. And in 2020, the 4 accused persons, the 4 convicts of Nirbhaya, were hanged. So though the penalty is there on our law books, the actual execution is very rare and only in extremely rare cases, which itself is an assuring factor against misuse of death sentence. But at the same time, merely because it is rarely executed can never be a ground to claim for its total abolition. I know there is a time constraint, so let me switch and let me also touch briefly the judicial journey of matters relating to death sentence and how Supreme Court has dealt with it. In Jagmohan Singh's case,
Aniket, okay, we just have to finish up in 20 minutes. So
yeah,
another 3-4 minutes, because
give me 5 minutes. I'll just wrap it up.
Would do. Yeah, please. Thank
in
you so
Jagmohan
much.
Singh's case, the constitutional validity was held for the first time. Then came the Bachchan Singh's case, where the rarest of rare doctrine was upheld by the Supreme Court, or rather coined for the first time. And it may be argued by many of those who say the death sentence should be abolished, that rarest of rare is a vague term, as it is difficult to know which case would be a rarest of rare case, and therefore possibility of wrong exercise of judicial discretion cannot be ruled out. To this, my simple answer is that our judges have judicially trained mind, and in respect of every offense, there is a discretion in terms of the quantum of punishment to be awarded to the accused, and this discretion is to be exercised by the judiciary on well-established, judicially recognized lines. So there is a very bleak possibility of any misuse or mistake. And thereafter, we also know that there are several safeguards in our criminal justice system itself. There are several filters through which a death sentence has to really go through. Even if a man is sentenced to death by the trial court, the appeal has to be heard by the division bench of the High Court. Only in confirmation, then the accused has a liberty to approach the Supreme Court, and thereafter he can file a mercy petition, where the Honorable President is expected to exercise his discretion in a judicious manner. In fact, what is expected from the President is not just to echo the grounds stated by the court, but must take his own independent view based on different parameters and not just what is reflected in the judgment. And therefore, we can see that there are several parameters, several filters. In fact, if we see section 235 of CRPC, we come to know that under subsection 3 of subsection 2 of section 235, the trial court or the court is under an obligation to hear the accused on the point of sentence before actually convicting him, and the court has to give special reasons for the purpose of handing out the sentence of death. Now, with this, I understand the time constraint. So let me conclude by reminding you all what happened 12 years ago. On 26th of November 2008, 10 individuals who considered themselves as Watan Parast Pakistani patriots created havoc in the city of Mumbai by mercilessly killing around 166 persons and injuring permanently around 238 persons. Those terrorists had no heart, no soul, no humanity in them. And the only terrorist who was caught alive was Ajmal Kasab, who was tried in Mumbai court, as you all know, and sentenced to death by the trial court confirmed by the Supreme Court. I was attending the trial of Kasab in 2009. And what really shocked me was that Kasab never had any repentance on his face during the entire trial, nor he ever expressed any remorse or regret. In fact, he always enjoyed the media glare that he was getting during the trial. Kasab gave his confessional statement in February 2009, before the magistrate court, not out of any sense of guilt or sorrow, but to present himself as a hero. He told the magistrate that he had absolutely no regret for whatever he had done, and he wanted to make the confession to set an example for others to become fidain like him and follow in his deeds. I don't think perpetrators of Nirbhaya, I don't think Kasabs, Afzal Gurus, Yaqub Memons, and many such offenders deserve any punishment less than that of death penalty once their offense is established in the courts of law. For such offenders, death sentence is the only appropriate sentence that is to be awarded, and only then we restore the faith of people in our judicial system. That's all. Thank you.
Thank you, Aniket. Thank you so much. Now, I'll hand over the discussion to Dr. Corin Gonsalves. Sir, your take on capital punishment and also the arguments raised by Aniket. Yes, over to you, Dr. Corin Gonsalves. So to switch on your microphone. Yeah. Please, thank you.
I think this is a very depressing way of starting a webinar. And I thought the ILS, with all its long history on human rights, and I knew Mr. Professor Sathe very well, and I knew the tradition he was in, and I knew the critical and learned discourse that was going on in the ILS in those days. And I have never heard anything more depressing than the talk I heard today. Obviously, the young man is very brilliant, obviously has a very bright future ahead of him. But that future is not in human rights. It will be in opposing lawyers like us who take up human rights cases. And I say this because it's possible to have a learned discourse, but not go back to the kind of language used 20 years ago by rabid anti-human rights people, calling accused people snakes, venom. I mean, I thought ILS Law College would rise above this kind of antiquated rubbish and present a more refined discourse, even if it is a discourse in support of the death penalty. Because I'm not particularly upset when I hear arguments, because we hear these arguments all the time. And we try to convince persons who are very strong proponents of death penalty. But there is a certain category of people you can't convince at all. I have convinced people who are the victims of death sentences. I remember in the earlier period, the parents and families of death sentence cases, they were very opposed to the death sentence. And when we asked them, madam, I remember after the TV program, we asked them, madam, why are you asking that he should be put to death? He will go to jail. It is a life sentence. And they said, no, after 14 years, he'll come out and, haunt us again. that was the period where death sentence was equivalent to 14 years. After 14 years, you got remission and you came out. But then the law changed and life became life, which means till the end of your life, you'll remain in jail. And in many cases, surprising cases, when I went up to either the mother or the wife or the sister of the person who was killed, and I said, but madam, please realize that law is gone now. Now it is not 14 years anymore. Life means life. He will be in jail for all his life. And the surprising answer that they gave, and I thought this was very positive, they said that if we knew that, we won't take this stand. If you are sure, and if this is the law, that he will remain in jail for the rest of his life, then we have no problem. It matters little for us whether he is hanged now or he is hanged or if he meets his death after so long. Matters little for us. And that was a very positive thing, that the revenge aspect in society. Indians are it's something to do. Other societies have it also. Some don't have it. But this eye for an eye, blood for blood, revenge, killing, massacre, mobs rioting, communal riots, burning people, hacking people to death. We must recognize that in our society, despite our glorious past, our glorious culture, our glorious tradition, etc., poetry, music, underlying society is a very revengeful, brutal aspect of Indian society, which we have not got rid of. We've not been able to get rid of that, So the first thing I want to say is that they realized that life imprisonment
Nitish sir, can you hear me?
Yeah, I think Colin sir, there's a bandwidth issue with you.
Nitish sir, I also want to respond to what he had
No,
said.
One second. Aniket will take afterwards. 1 second. Let's finish. We'll take the issues afterwards. Okay. Colin sir, there's a bandwidth issue with you, I suppose. Hello.
Yes, sir.
Aditi, please make a call.
Colin, sir. Yes, sir.
Prasanna Vijay Kumar, please switch off your camera.
I think the bandwidth is not.
1 second. Aditi, yeah. Yes, there was a bandwidth issue, so we can't hear you, and then your relay got disconnected. Yes, sir, please continue.
I'm told there's a problem at your side with the services. I don't know.
Because we all were live here. I don't know.
Okay, I think it might be anyway.
That's fine, sir. Yeah, please.
So there's a historic shift in the law. And so many judgments of the High Courts and the Supreme Court that call for the death penalty and rely on judgments prior to Swami Shraddhananda's case may not be good law at all. So the law is in great confusion. People are relying on a lot of judgments of an earlier period. But what Swami Shraddhananda did was it filled a gap in the law. Prior to Swami Shraddhananda's case, there was either life imprisonment or the death sentence. And there was a certain degree of discomfort felt in society that, all right, you give life imprisonment, but this is a very serious crime. It's a terribly serious crime. And then to have a man in jail for 14 or 20 years and so on is not good enough. You need something. But then the other alternative was just the death sentence. So was there a possibility of an intermediate standard? And Swami Shraddhananda laid down that intermediate standard, which was that the courts itself would have the power to go beyond the statute and give imprisonment up to death. So it's not life imprisonment, which always has the inherent possibility of remission, but it was life sentence until death. Now, once that happens, the rationale for hanging a man, namely, he will come out, or the punishment will not be so severe, or anything else, basically evaporates. Because now you have an alternative punishment that is equally harsh. Unless, of course, you have people who want to have a demonstration. Like there are some people, many people, I suspect, in your college, if you ask, perhaps you'll have people putting up their hand that we should have a firing squad. In a place like Jindal, I remember when I asked the students, firing squad, students put up their hands. That should you have public hangings like you had in the old period, and everybody gathers around and watches the public hanging. Unless you want a spectacle and you really are bloodthirsty, you will realize that, life unto death, life until death, and hanging is equal. Now, once you overcome this gap in the law, then there's no real reason why one should have the death sentence anymore. And the death sentence has outlived its utility, and even the most bloodthirsty persons will find it very hard-pressed to say that no, keep him in jail for 30 years, 40 years is not enough. We must take his blood. And I have seen many cases, because I heard my dear friend Ankit speak about some of these cases and all that. I saw the Rajiv Gandhi assassination case, who were in their 20s or 30s when they, did that bomb. And I saw them in jail when I handled their mercy petition. And as I entered the jail, you can't believe this, but I have seen many, many cases, almost all cases, of persons who commit the most heinous crime become a new person in jail. There are very few who remain rabid, killing, violent, become a new person. And as I entered that jail in Chennai, the superintendent of the jail comes up to me and says, "Sir, save this man." I said, "What do you mean? You're the superintendent."
Aditi, could you just find out what's wrong?
Yes, sir.
Convict prisoner, which I did. And he was a thoroughly reformed person. And I wish sometimes that judges who are sentencing people to death should spare 1 hour with them in jail. And in the presence of the superintendent of the police, talk to them and see how marvelously reformed they are. And in fact, the best indicator of reform, is the prison record. Because by the time you go to the mercy petition stage and your hanging date comes, the prison record will show clearly your conduct in jail over that 10-year period, maybe more, from the time of your arrest to the time of your order of the Supreme Court sentencing you to death. And I would say that in something like 90% cases, if not more, the prison record will show that the convict prisoner on death sentence today is a remarkable young man or middle-aged man or whatever, but that he's a completely reformed person, and there is no possibility at all of him repeating his offense. So it's practical experience. I remember another person, the famous Pune case, where there was a Baba who convinced people that he can shower them with gold. And he took them up a mountain, and there were some people helping him. And he took them up, took all their money and threw them into the valley. And those persons ultimately were released, not released, were commuted. And I remember the justice looking at the book the men had written on Mahatma Gandhi and nonviolence, looked at the certificates they had got from the colleges, they had passed classes. And he was thoroughly convinced that these people are thoroughly reformed. And that is the only criteria. Are they capable of reform? And once they are capable of reform, there's no question of society hanging them. Now, why do you hang? There are two. Rarest of the rare is a very clear thing now, as enunciated by the Supreme Court. And the most common mistake made. Now, the first common mistake is not looking at Swami Shraddhananda's case at all. But the most common mistake made is looking at the heinousness of the crime.
You have lost his connection, Naveen.
Yes. So yes, sir, he's there in the meeting.
Yes, someone please call him.
Yes, sir. Yes, sir.
Yeah. So your microphone. Yeah, sorry. So we are at the point of the first, yeah, we were at the point that the first mistake is relying on Shraddhananda, and the second point you have to take.
No.
That was the point when we lost your connection.
No. The first point I made was that reliance is not placed on Shraddhananda, and the importance of Shraddhananda is not seen. And judges are going by the old law and getting death sentences without looking at Shraddhananda, that now I have a new option, which is not there in the Criminal Procedure Code, which is not there in the Indian Penal Code. I have a new option. I don't have to give life only or death as an alternative, but I have a new option. I can keep him in without remission. That's the first point. Now, the second point is, I look at the serious nature of the crime. And if you look at recent judgments of the Supreme Court, you'll be surprised to see when you read those judgments, how even senior judges like Supreme Court judges make the most elementary of mistakes. Because Bachan Singh says two requirements: serious crime and incapable of being reformed. Now, circumstances of the criminal. So the courts will not look at circumstances. The courts will look at the seriousness of the crime and lament about the seriousness of the crime and not look at that. Now, the second, I want to go to the second limb of the rarest of the rare requirement, which is the circumstances of the criminal. What was he like? What was his life as a child? What kind of violence or discrimination or sexual abuse did he face? Going further on, what did his teachers say of him? Why did he commit this crime? Was it a one-off impulsive thing? Heinous crime. He killed a family. Heinous crime. Right? And then you go to his performance in jail. 10 years in jail. What was his behavior like? And when you look at the circumstances of the criminal, and if you look at, you must study this National Law University Delhi as a death penalty project. And the lawyers on that project are some of the finest in the country. So they go to the areas. Can you imagine in a death penalty case, where lawyers who are doing legal aid won't even bother to meet the prisoner in jail. Can you imagine? You're conducting a death penalty case and you won't go to jail to meet your
Losing his connection. Is anyone working on it? Please call up Mr. Gonsalves. We're losing his connection.
Yes, sir, we are
Devai?
calling him.
Yeah.
Yes,
Yeah.
sir. So we are calling him.
See if he could, maybe he could.
Nitish ji, how long is it going to go now?
So we'll, if you finish up, then we have the question answers for Colin, and then we have other two speakers.
Okay.
Yeah.
Yeah, am I running out of time because this internet is breaking up?
So we have another
frequently?
5 minutes and so. Because this internet connection,
All
you
right,
can take some more time, but then we have spare time for your question answers because you have to leave by 5.
No, I
Yeah,
realize.
please.
And so you look at the circumstances of the criminal, and in the cases that I've handled in collaboration with NLUD, and the kind of reports that they prepare on the accused, I can tell you it makes you turn around 180 degrees. Because now it puts flesh and blood on a name on your file. You look at a paper and you don't get any idea of this man or this woman you're representing. And his history, his work in jail, his contribution in jail, his role as a model, a convict prisoner, and so on. You get no idea. And all of a sudden, when I do these cases, you say, my God, he might have committed a heinous crime. In most cases, it was his first offense. In many cases, he was a young offender. In many cases, there were terrible trauma and circumstances that caused him to do an impulsive action. And look at it. We are putting this person to death who has so much to contribute to society, notwithstanding his crime. And after all, we're not releasing him. When you do a death penalty case, you're not releasing the person. You're just taking him from the noose to living his life in jail without remission. So circumstances of the criminal have resulted in many cases, if you look at people being released. Poverty is a huge issue which the NLUD have discovered. They go to the village and they look at the absolute destitution of the person, the miserable life he led, the exploitation by, dominant caste people and landlords and so on, which led him at a certain point to do something very harsh, very brutal in an impulsive way. But his character was certainly not that of a person who is incapable of reform. It's like the story of Buddha and Angulimal, who was a terrible, terrible man who killed people and cut off their thumbs and so on. And then he came in the presence of the divine Buddha and understood. And the Buddha saw in a despicable man. The Buddha saw in a man who was a murderer and a killer, and a man who society thought was beyond repair. And Angulimal was changed. I believe, and whatever little work that I've done, and I've met a lot of people. I met Afzal, about whom people talk so much. I can tell you his story. It's a totally different story. He was completely reformed by the time he was hanged. He was spiritual. He was completely a devout person. He did what he did on the instructions of the Jammu and Kashmir police. And now it's come in the papers, you know, that policeman who's in league with the, he told Afzal, if you want us to stop harassing you, he has started a chemist shop. You will take people who will come to you and you will take them and find them a car. And Afzal in court said, yes, sir, they came to me and I found them a car. And the court convicted him because he admitted, quite frankly, in front of the court, I found him a car. And he was told by the Jammu and Kashmir police who were harassing his wife in Kashmir, take him there, that's your last job. After that, we will not harass you. And he did it. And now it's coming in the papers 20 years later that these constables are found in league with the underground and so on. So I know a lot, I've met a lot of these people personally and so on. Now, before I end, I'd like to say a few words about this criminal reform agenda. I want you to be very, very, careful of that. Because this government, when it says criminal reform, it means tightening the screws on the ordinary people. You know what we have today in India, right? You have surveillance, you have all kinds of Arogya Setu app following you around all the place, invasion of your privacy, making laws even more stringent, etc., etc. This is going to bring in reforms such as, let me tell you, it's all predetermined. And then they'll have this farce of calling you to fill up a questionnaire. This will introduce confessions to a police officer. Can you imagine? And videotaped confessions so that you won't have trials anymore. You torture a guy, torture his wife, torture his family, threaten him like this and that if he doesn't make a statement. And then he'll go before the police officer and make a statement. And that will be the end of the trial. They want to bring in that. Among other reforms, this is a big thing they want to bring in. So I'll stop here. But let me take 2 minutes on one small thing. About this great, what Ankit said, thoroughness of the criminal justice system. It's very thorough when it comes to rich people and middle class people like you and I who've got a good first class lawyer. But when it comes to legal aid cases and poor people who have no money to spend, legal aid lawyers care a fig for them. Take Om Prakash's case, he got a death sentence. Matter came to me after his conviction was upheld in the Supreme Court. I opened the papers. First thing I saw, juvenility certificate. And I looked at the record, there is no reference in the Supreme Court order of the juvenility certificate. I phoned up the legal aid lawyer. I said, Madam, there's a certificate. She said, what can I do, Colin? Nobody pointed it out to me. So the lawyer briefing her doesn't point out, which is on glaring at you, the juvenility certificate. So I tell the judge, sir, there's a juvenility certificate. He said, what can we do, Mr. Gonsalves? We have dismissed review. Second review is not permissible. And to cut a long story short, I did a lot of jugglery, and the judges helped me. They were very kind. They ignored certain technical and they heard it again. And he was acquitted because his juvenility certificate was not taken into consideration. Murdered the woman in the house. And there were processions in West Bengal. Hang him, hang him, hang him. Based on what? That he was found with a chain. And he had a particular button on his shirt. But what convicted him was that chain. A part of that chain was found near the body of the lady. And the story from his side is, Dhananjay Chatterjee, that this was mine, sir, but I gave it to my colleague in the adjoining house, servant colleague in the adjoining house. I gave it to him many years ago, and he used to wear that. And that is my defense. It was not worn by me. It was worn by my colleague many years ago. But the legal aid lawyer never caught that point because legal aid lawyers are not interested. So let me tell you, for death sentence cases, for poor people, the legal aid system in this country is a Raddi system. And it needs to be thoroughly reformed. And that woman who did that case of Om Prakash, when I called her and said, Madam, and she told me also, apart from the fact that the certificate was, she said, what can I do, Colin, sir? I got 750 rupees for the entire case in the Supreme Court. So what could I do? I had to rely on the instructions. I didn't even read the papers in that case. So thank you very much, my dear friends.
Thank you,
very
Colin,
much.
sir. There are a few questions in the chat box, and I suppose Aniket also want to respond to a few of the issues, and also other speakers if they want to respond, because after this, Colin will be leaving at 5, and we'll continue with the thing. First, we'll take the questions. Yeah, Aditi, who's going to read the questions for Colin, sir?
Nitishji, before that, can I come in for a minute? If you don't
yeah,
mind?
fine.
Well, I think ILS always has provided a privileged intellectual platform where every speaker has liberty to express his views, and that has been the history of ILS. I have immense respect for Mr. Gonsalves. He may disagree with my views, but certainly that does not give him a right to make comments or pass comments below the belt. He's a senior lawyer. I have utmost regards, highest regards for him. And my upbringing teaches me self-restraint, and therefore I would not comment or retort in the same manner the way he did. But let me also say this, that when I spoke about snakes, I spoke about what Salman, the father of jurisprudence, had said. So, Mr. Gonsalves, he's got a problem with snakes and comparing snakes with criminals, hardened criminals. That's not what I have said. That's not my words. Those are the words of Salman, who is treated to be the father of jurisprudence. So we may have different views, we may disagree with each other, but let's not debase discourse.
Yes, Aniket. So, well, that is who said what, and he responded initially. Colin sir was responding that the way we started was quite depressing, because we started in favor of capital punishment, and then rebuting the argument comes in.
No, I didn't say it was depressing because it started in favor of capital punishment. I never said that.
No, that's okay.
Yeah, of the manner in which. The very below the belt way in which the discussion started. That is my objection.
Which are the words?
Fine. Let us take Aniket. Aniket, you can also review it back with the other arguments which have been made by Gonsalves sir at the end of the discussion. We have few questions for Colin sir, and I suppose there are questions in chat box. Aditi, who's reading the questions?
Yes, sir. I'll be reading the question.
Yes.
The first question we have is for Colin, sir, which is that, sir, even if we are considering the reformative tendency of a criminal, that he or she must have reformed or have realized his mistake, but how is that any justice to the family or person who has lost everything because of the inhuman crime committed by the person? So they are basically talking about victims' rights and how victims' rights are being affected here, and how this is affecting the victim. Also.
Yes, see, the answer to that is,
yes,
we can never compensate the victim. We can never do full justice to the victim. You lose a family member, right? Nobody, no amount of money can bring that family member back, right? We understand that. And now the law is changing to talk of compensation and so on, but no amount of money. So that's a fact, that there's nothing society can do to reverse those things. But then, don't forget, the argument and the discussion on the death penalty is not meant for the accused and the victim alone. It is for society as a whole. It is for all of us. Because when we go by violence, when society prescribes violence, and when society prescribes the taking of life, it sends a message out to society that revenge is all right. Eye for an eye is all right. The man killed somebody, let's go and kill him. And you've seen it on television, isn't it? So retribution, once it starts, it affects society in a terrible, terrible way. So when we discuss this issue, it's not just for the victim or for the accused. Is for what kind of standards do we want to set in society?
Yeah.
And so if you look at Europe and some of the terrible terrorist acts committed in Europe, You must watch those proceedings. The trials are done in a very dignified manner. There is no hatred, hate speech, anger, shouting, none of that. Even the victims' families, you know, you punish with the maximum possible effect. But you don't have the kind of discourse you have in India, which is a very kind of aggressive blood kind of approach. You don't have that. So sentencing is not only for them. It's so that society behaves in a manner not like the accused, in a civilized manner.
Yeah. Thank you, sir. Basically, it is also how civilized we are as a society. Our criminal justice system reflect it. Our criminal law should reflect it also.
You remember Sonia Gandhi's response to punishment in Rajiv Gandhi.
She said, I've forgiven them.
I've forgiven them. I'm not asking, even if you don't say I forgive them, I don't forgive them. I hate them, but I'm not asking for the death sentence. That's the level of civilization.
Sure. Aditi, one more question and then we'll move to the next speaker because we're also running short of time. If there's any question, one more question we'll take.
Yes, sir. Yes, sir. So the next question we have from a student is that how do you approach rape cases, and do you think that we should look into the background of the accused and what they have been through? As human rights lawyer, what are your views, and who is to know for sure that they have actually transformed? And do you think this is being practiced well in the society? So do you think while sentencing is being decided, do you think the judges look into the prison reforms and the prison reports, and are they being looked into in the system?
See, when I spoke about looking into the background of the accused, it's for death sentence cases.
Yeah.
Right? It's not a general rule, although I think should be a kind of a approach of a judge to look into, because some of the people committing rape are juveniles on the streets who've been raped themselves and so on. But I was talking in the context of death sentence only. And rape is rape. Whatever the punishment is, according to me, the maximum punishment should be given.
Okay. Yeah. Thank you so much, sir. So this were the questions we have for you. Thank you for joining us. And we have our next presenter, Shreya Rastogi. Shreya is from National Law School, Delhi, and she works on the famous project of 39A, which Colin sir made a reference to. And Shreya is going to make a presentation about the project and her views on the same, on the capital punishment. Yes, Shreya, over to you now.
Thanks, Nitish. And I just wanted to, as I begin, I want to thank ILS Criminal Law Cell for inviting me to speak today. It's been an interesting discussion so far, and I also do want to thank Mr. Gonsalves for his high praise that he's given for our work. We've had my team and we've had a wonderful time working with him on some of our cases, and actually, some extremely tough cases for sure, but it's been a really good experience on those cases, one of which actually also ended in an acquittal. Anyway, so I thought that I'll first begin with, given that I'm the third speaker in the row now, I thought I'll first begin with just touching upon some of the issues which Aniket had raised. And I think that they're extremely important issues. These are things that are said about in support of the death penalty, and I think it's important to kind of address them. So I would like to first start with that, and maybe then move on to some of the other points that I'd like to make. So for me, unlike the way in which Aniket began the conversation about how we should maybe think about capital punishment in India, for me, I think the main thing for us to do would be to, when we're beginning a conversation on death penalty in India, it should not be a conversation just about the punishment itself and theoretically the way that it has found a place in our statute book and how it may be given out. For me, it's best because it is the harshest punishment that is there in our statute book. It's more important for us to actually see how rigorously is our system, criminal justice system, working, how fairly does it work, and that for me should be the starting point before, as we begin to think about the appropriateness of this punishment. I just want to at the outset itself say that I'm not, as part of what I'm going to be saying, I don't want to necessarily take a position for or against the death penalty. For me, honestly, as a lawyer who's worked on this on these cases for the last almost 6 years, and as a person who's been researching in this area, I want to say that if I was to comment on where we are about as a society, as a legal fraternity, where we are in terms of our understanding on the death penalty, I think there's a lot that needs to be explored. There's a lot that needs to be researched before we discuss and pass our judgment on, yes, the death penalty should certainly exist, because it is moral to kill someone who's taken another person's life. For me, that is a very, while it's good to talk about the morality of this and look at it from that philosophical lens, I think there are serious dangers in limiting the conversation around the death penalty just to that. And the two main aspects about this that I'd like to raise before you all today is, I think it's problematic to do it just about whether the death penalty is appropriate or whether the state should be allowed to kill model of discussion. I think it's problematic to restrict the conversation around that, because what we don't do when we're not thinking beyond this is we first don't think about the inequities and the arbitrariness which is just so inherent in our criminal justice system. I think that's an important aspect that gets missed and certainly needs to be considered. And what do I mean by this, right? Like, what I mean is, first, we need to ask ourselves, is our system robust enough? Is it strong enough to accurately and reliably ascertain if a person is actually guilty or not? And here, I don't want to go by just by what's there in our IPC, in our CRPC, in our Evidence Act as theoretical provisions, right? Because on theory, on paper, our system is fantastic. Many people, many scholars around the world have in fact probably may say that, yes, the Indian system has so many protections built into it. Our constitution is so vibrant, so robust. There are so many protections which are awarded there. But we really need to be having a conversation about how does it actually play out in practice. So many of us as criminal practitioners, as criminal law researchers, as law students, we felt that the system as it exists in theory and the way that it is actually practiced, they're two different realities. And we need to see the reality as it currently exists, right? And that reality is a really ugly one. That reality will show us the number of wrongful convictions that have happened. And I don't think those can be refused just by saying that, no, but in the next case where people are sentenced to death and where people are actually probably finally executed, that we've got it right. Because our system has come so close to getting it wrong. We've had cases like the Akshardham attack case where after spending 8 years on death row, 6 people were acquitted, right? We've had the Shinde's case from Maharashtra, which I'm sure many of the people here will know, where 6 men belonging to the Dalit community, they were convicted and sentenced to death for killing a family, including a rape of a minor girl. And they were, after so many years, after the law finally, like even the Supreme Court having finally decided their conviction, and only because there was a change in the law where those cases where review petitions were dismissed in chambers, they were allowed to bring their cases back. It got reheard by a completely different bench, and only then did that bench find them to be innocent, right? So we've seen how close our system has come to actually failing, and so let's not pretend here that our system is absolutely correct and fine and everything goes right in the system, right? And these are just a few cases that I'm taking by name. We've done our research where in the last, from 2000 to 2015, we looked at all of the cases where the death sentence was imposed in India at the trial court level, and we followed those cases up till their judicial hierarchy, up till the Supreme Court. And would you believe that in those cases, 29.8% of those cases, right? That's almost 30%. That's one in, right? That those many number of cases, you actually had people who were sentenced to death, their convictions were overturned, right? So they went from being on death row to actually being acquitted. That's the rate at which we're working at. So I mean, if this is the level to which your system can go bad, and this is the national average that I'm giving you. In states like Bihar, the acquittal rate was 49%, right? That's a flip of a coin. Let's just let that sink in before we say that our system works absolutely perfectly and that we always get the right answer and that we always get the person who's actually committed the offense. And this is just the conviction aspect of things. There is a whole other series to this and the whole other discussion that should happen even beyond that, even beyond the fact of whether we've got the right person, because we don't have kangaroo courts, right? We don't want to have that. We don't believe in mob justice. We are a democracy. We are a rule of law. And there are procedural safeguards that are inbuilt in our system. And we find that those safeguards should be, I mean, the law as gloriously written down by the Supreme Court says that it should be given to every single person, irrespective of whether they committed that offense or not, right? And so therefore, whether you're a Kasab or whether you're an Adam Bhai Ajmeri or whether you're an Ankush Maruti Shinde, anyone, you should have the same protections under the law. And those protections are often violated, right? So this fair, just, fair and reasonable process that our criminal law should have, I think we really need to, as a society, need to think about how much of this actually gets realized. The second problem that I think of just restricting our conversation to the philosophical and moral front is really that, and this is something that Mr. Gonsalves touched upon, it is the fact that we choose to very conveniently ignore how violence and crime is bred in our society, right? I mean, we make this conversation just about punishing that one murderer, that one rapist, that one terrorist, and those cases which get blown up in the media, and that's all that you hear day in, day out. First of all, I'd like to say that most of the prisoners who are sentenced to death in India, they live a life of ignominy. Most national press does not cover those cases. These cases, of course, there's a lot of pressure in these cases, and that pressure is mostly localized. But beyond that, many of the people here would not even know the names of so many people who are actually currently serving their sentences on death row and have been for several years, right? So here, I'd just like to say that the issue that we really miss out by making it just about that one person and the terrible act that they did and not looking beyond that is the fact that we don't choose to look at their lives before this crime happened. How were they brought up? What has been our own collective role as a society in bringing them to the point where they reached? And in this context, I definitely want to talk about the problem of sexual violence, right? Even Aniket referred to this. He referred to the Nirbhaya case. Now, to say that the what happened in this case and like what finally whether these 4 men should have been executed or not, that's not my real concern as of now, right? Because that has happened. What I would like to talk about, however, is the fact that have we as a society thought enough about how sexual violence is allowed to be perpetrated in our society, how it is not just perpetrated, right? Like how it is celebrated, how it is just ignored when and how people are allowed to like do these kind of things, and how we choose not to correct them in the right way possible. That is a conversation that we don't have. And that is certainly a conversation that we should be having if we are actually, if our real interest in this, like Aniket said, is about making sure that these crimes don't happen, that people are deterred, that there is some change that we finally see. Now, what is the one resounding factor that we know about the nature of sexual violence in this country? NCRB data itself tells us that 94% of the offenders of rape, be it of adult victims or be it of rape of children, 94% of those offenders know the victims, right? So it is someone who is there in your family. And how does this factor become relevant? Because look at the way in which these cases actually get tried and convicted. You have the lowest number of conviction rate in sexual violence cases in our country. Again, NCRB data clearly shows us that. Yet, we choose to create the conversation around sentencing. If only 29% of the rape cases, again, as per NCRB data, if only in 29% of the cases are we even getting close to convictions, right, in POCSO cases, then why are we saying that we are really actually even, having the death sentence for rape and murder of the children, that's what's going to solve this? Because if you're not first convicting people, if you're not able to convict them, then how will you even be able to sentence them, right? And that is something that I would like all of us to bring our focus to, and then think about what does the system need to become much better. Because I do believe, I think I agree with Aniket as he says that yes, the system should work properly, it should work fairly, it should, these cases take way too long to happen. There is a lot of delay that happens in the investigation of these cases. Just last year, there was data which was submitted before the Supreme Court about this, and we saw some really terrible figures about how most of the cases where investigations were pending for more than a year. This is in POCSO cases, right, where the law is more stringent in terms of the amount of time that should be there and has been statutorily now put down. Yet you have that high level of pendency, even just as far as investigations go. So absolutely, those would be the things for us to correct. But when we start thinking about that, we will realize that there is something very different that our system needs. And it is at this point that I want to now bring to something that I wanted to begin the conversation with, which is that how well does our criminal system work, right? And in this aspect, I would first actually like to talk about, sorry, Nitish, how am I doing on time? Hello, sorry, you're muted.
Ma'am, you have around 5 to 8 minutes.
Yeah.
Okay, great. Thank you.
5 to 8
Yeah.
minutes.
So I just want to share a few facts and figures from extremely well-researched reports. These are all publicly available online, and I really encourage all of you to go back and look at these because before we, as I'm saying, that before we take a decision on whether capital punishment should retain a place on our statute books, I think we need to be very well informed about that. So the first thing that first aspect on which I'd like to share some data is how well does our criminal justice system overall, how well does that work? And as part of that, like, what's the first place where any of this begins, right? It begins with the police, it begins in a police station. If we look at the data that is emerging from reports of, the Tata Trust report came out last year, the India Justice Report of 2019, which had a cohort of human rights organizations and data organizations coming together and actually examining publicly available data, and then that's how this report has come out. So I just want to emphasize this is not some report, and these are not figures which are just made up or come with a certain ideological frame of mind. If you look at that data, what does that show you? It shows you that there is extremely high vacancy rate amongst our police personnel. Right, it shows you the number of police people that you have per 1 lakh population. The sanction strength in India, if I can just tell all our viewers here, the sanction strength in India is 151 police personnel per 1 lakh population. right? And you have states like Uttar Pradesh, where the actual strength against this is the national average. Against this, the actual strength in states like Uttar Pradesh is actually 90 and Bihar is 75. Now, why does this matter? Because imagine the system in which your police is working. You've had the Prakash Singh Badal's case in 2006, which directed the investigation and law and order requirements to be segregated. And I think all the practitioners here would agree with me that that is not a reality that has come to pass. So this is the environment in which your police has to work.
Yeah. Shreya, I just say that we just have another speaker to speak and then other question answers to taken. Okay. So if you could wind up early, we have the speaker, because anyway we're running late a bit. Please.
Sure. Yeah. So I mean, in terms of just the other reports, I would also say please do look at the report of Status of Policing in India report, again a CSDS report which was released last year, and in light of what has been happening in the past few days, I just want to take some time to bring to fore this specific data that has come out from this report. Now, this report actually, for those who may not know, over 11,000 police personnel were actually surveyed in this. So that's how they've brought out this report. And a chapter on this talks about the attitudes that the police has. And it's really problematic to see that 4 out of the 5 personnel, so over 80% of the police personnel, they actually believe that there is nothing wrong in the police beating up criminals and extracting confessions. Now, this is no longer about, yes, you may say that this is no longer about the death penalty, Shreya. We should all agree that, yes, torture should find no place in our criminal justice system, and we completely reprimand this, but this has nothing to do with whether the death penalty should be there or not. Actually, it really does. Because if this is the reality in which your system is operating, unless you correct this, can you actually say that the way that those criminal trials, which ended up in the death penalty, happened properly, happened fairly, happened as per just, fair and reasonable procedure? I don't think you can, right? And that is what our focus should be on. So I'd just like to, I guess I'll leave this here. I had a lot more data to share from our own Project 39A reports about the way that the death penalty has actually played out, but I can probably take that up in the Q&A. Yeah, thank you.
Yeah. Thank you, Shreya. Advocate Desai, over to you, sir. And yeah.
Well, sorry, I've been pushing you a little bit, and then we have been running very late on this whole program, and most of your viewers are also probably on a Saturday evening leaving for better entertainment, rather than a whole discourse on the death penalty and whether it should be continued or not. But I have taken a slightly different approach. So I title my talk "To Hang or to Die," and in addition to the multitude of academicians, juries, judges who have written on this topic for years, and we have heard the views of opposing death penalty, supporting the death penalty. Death and lust have had the highest TRPs, and despite decades of these debates, where most of the arguments are all the same with a few additional statistics to support both views, this topic still attracts the most discussion and debate in the realm of criminal jurisprudence. The topic of to have or not to have has been done to death over the last 100 years. The abolitionists and the non-abolitionists have argued the pros and cons of the death penalty. The academicians, the jurists, the judges have written for it and against it for years. The governments have, generally speaking, invariably supported it. But there is once again an opportunity to re-debate this issue, since the government is examining criminal laws and have set up a committee to make recommendations. Though, after what Colin mentioned, and he might be having some insights into this committee, I am, as a practitioner in this area, very, very concerned about what he just said. But as students, and that's where we are today, because you are the next generation here who can keep this battle going, you must be keenly aware of the theories of punishment. The death penalty is now being upheld, recognizing the doctrine of retribution. In my view, the heart of the problem is the construct of our life-giving fundamental right under Article 21, the right to life and liberty, the fountainhead of our constitutional being. This article upholds the doctrine of reverence for life, but it also recognizes the penological doctrine of retribution. It gives the right to life, but also it gives the right for the state to take life. From the lens of the victim, the death penalty provides them with a sense of closure, and on a broader level, a sense of relief to society that such a criminal is not a part of society anymore. However, from the lens of the criminal, the death penalty dilutes his human rights, especially his right to life. So the conundrum between having this form of punishment in our justice system and the use of this punishment takes one into the thicket of the sentencing guidelines and its application by the criminal justice system, which is the trial courts, which are the first level in the dispensation of justice. And that is the area which I wish to focus on rather than all the other debates and the specific cases and where the mistakes have happened and not happened, etc., rather than policy debate, which is what we should be doing on this particular webinar. But I wanted to start with a relatively new development of what is relevant for this debate. We are aware of the rarest of rare jurisprudence. Unfortunately, the court in Shraddhananda's case in 2008 has now created one more category of punishment, a punishment between death and life with remission to life without remission in cases where the court feels, and that's the important issue for me, feels that the case falls within the rarest of rare and where one feels reluctant in endorsing the death sentence. I'm very concerned with the language in the Supreme Court judgment when it gives an alternative to the death penalty, and the one sentence which has become the basis for this entire conversation today, it only says this in the entire judgment with no further discussion. This court may find that the case just falls short of the rarest of rare and may feel somewhat reluctant in endorsing the death sentence. But at the same time, having regard to the nature of the crime, the court may strongly feel that a sentence of life imprisonment subject to remission normally works out to 14 years would be grossly disproportionate and inadequate. How does one determine this? What is the criteria to feel somewhat reluctant? How does the sentencing court, which is a sessions court, come to this feeling? How does the judge, who is already burdened with the complexity of the Bachchan Singh principles, now draw this distinction? What is rarest of rare out of rarest of rare? There is no indication or legal basis for this form of punishment. What is the power of the court to create this category of punishment? Sriharan's case in 2016 by a majority of 3:2 upheld Shraddhananda's case on this special category for punishment. The minority view of Justice Lalit and Sapre, in my opinion, have rightly held that there is no power in the court to create this special category of punishment. The Constitution Bench has held that this punishment can only be awarded by the High Court or the Supreme Court. It has taken away the power to impose this form of life imprisonment by the original sentencing court. Now to do so would now encourage the trial court to award the death sentence in more cases and transfer the sentencing process effectively to the High Court and lighten its burden on dealing with this complex issue of sentencing. Also, this would unnecessarily burden the superior courts with such confirmations and appeals. What then happens is that the trial court is now rendered as a court commissioner who records evidence, appreciates it, expresses a recommendation on guilt, but does not pass effective sentence. On the basis that the death penalty is a reality in today's India, this new carve-out actually dilutes the debate about retribution. We have it in our textbooks that the death penalty is to provide not deterrence, but retribution, that is revenge for society. And maybe that threat is a form of deterrence. But when we decide to award the death penalty in its traditional form or in its new Sriharan form, we curtail that power of bringing the doctrine of collective consciousness of society and various other principles set out in Bachchan Singh and the subsequent line of cases. These cases which sought to balance the competing needs of the abolitionists with the non-abolitionists, I must say here, which is what Bachchan Singh tried to do. And whilst you may bring about the balance and I may not disagree with it, the form of Sriharan, if it is to be accepted, and I have a view on that, must come only within the legislative scheme, because what the Supreme Court has now done is to create a new form of punishment which does not exist in the scheme of the IPC or the CRPC. As budding lawyers, you will appreciate the importance of hard facts. Despite the guidance of the Supreme Court since Bachchan Singh, it is unfortunate to see the statistics of Project 39A, and I'm glad that Ms. Rastogi is here, which revealed that over 15 years, till 2015, the trial court sentenced 1,700 people to the death penalty, of which the appellate courts confirmed only 4.9% of the sentence, and 65.3% of the sentences were commuted to life. And more recently, in 2019, the trial courts have convicted 102 death sentences. They are given 102 death sentences, whereas the Supreme Court has confirmed only 6. This essentially shows the complexity of the problem of sentencing, where at the pyramid of the criminal justice system, which is really where the heart and soul of the criminal justice system is, where sentencing is meted out, it is that court which should really be determining the question of sentencing and not the appellate court and not the Supreme Court in all such matters. Sentencing is the soul of the criminal justice delivery system, even if a fair trial is its heart. In some sense, it is more difficult than the trial and the determination of guilt, especially in cases where death penalty is a form of punishment. These figures show that the sentencing courts have still not got the message of the Supreme Court. Is this because of the subjectivity perceived in the guidelines? What is collective consciousness? What is brutal? What is diabolical? And the like. Is it the Jessica Lal collective consciousness which gave life imprisonment? Or the Nirbhaya's collective consciousness which gave the death penalty? Is it the brutality of Sushil Sharma which gave the life sentence? Or the brutality of Kasab which gave the death penalty? Is it the Rajiv Gandhi assassination principle of commutation? Or the Yaqub Memon bomb blast principle of refusal of commutation? You see the inconsistencies and contradictions in entire process of sentencing and the inability of the sentencing court to really appreciate and understand these concepts which are settled by the Supreme Court in these numerous judgments. Before I end, I would like to go back to the jurisprudence of Sriharan's case. This judgment has created a new form of meting out the death penalty. Once you pass a sentence for life without remission, the court has effectively condemned the prisoner to death penalty, as he must live his natural life within the four corners of a prison without hope of release for good behavior. We've heard Colin give so many of his examples: repentance, rehabilitation, reformation, age, health, etc., all of which are within the domain of an authority which looks at the provisions and determination for remission. It is not death by hanging, this new form, the Sriharan principle. It is not a death by hanging, but it is a death by living till the body gives way. It is a form, it's just another form of a death penalty. By now you would have realized I'm not a fan of the Sriharan principle. If the state thinks that the person deserves to die without remission, there is no need to keep him alive. If the state believes that they should be given another chance, the sentence of life without remission means that the chance will never arise. We must be clear in our minds as to what we want to do with such convicts. But to keep them in a jail for decades together itself, in my view, violates human rights, because it's just another form of the death penalty. I've tried to categorize the jurisprudence on death penalty throughout the years into three main phases, and I think 39A will obviously have a lot more on this. But one is the death penalty as a rule, which was the 1950 to 55 period, if you see the trend of judgments. The judicial discretion started coming in a lot more between 1955 to 1980. And then, of course, there was the Bachchan Singh era from 1980 onwards. But we now have, from 2008 and reaffirmed in Sriharan, is the Shraddhananda principle of life without remission in rarest of rare cases. And I'm still wonder whether the trial courts, the sentencing courts, or for that matter, even the High Court would really appreciate and understand what is this area of life without remission in the rarest of rare. Because in any case, Bachchan Singh had introduced the principle of rarest of rare, and you now have a rarest of rare of a rarest of rare. So we are still struggling in that area. These phrases reflect the mood of the court to move away from the death penalty towards life imprisonment. The question before us today is that we have a legislative opportunity to reflect this mood, to limit the difficulties faced by the sentencing courts by limiting the number of offences which provide for the death penalty, and in my view, for removing all offences for life without remission. All that we need to do simultaneously is to strengthen the procedural aspects of remission, because there has been a lot of debate and comment both in Shraddhananda and in Sriharan to carve out this particular concept of punishment called life without remission because of the problems in various states about how remission is to be looked at and how governments and administrative and executive authorities look at remission and the problems there. But that is not the reason for creating another form of death penalty. All that you've done is you said that instead of death by hanging, you now have death by living. So I think the debate and the conversation, I'm sorry, but we've run out of time, and I'm trying to really cut back on all this because, we've gone through a lot of issues. But I think the issue for this audience, and as Professor called and told me, that you want to use this platform today to consider how to represent to the government, and that's one primary reason why I'm here, is to use some policy principles, some legal construct arising from these two judgments, arising from the evolution of the law, which 39A should be able to help you on death penalty, to either bring down the cases, because there is always the question that will be asked in our society in India, that did Kasab deserve the death penalty or not? And that is a societal problem that needs to be addressed by policymakers. I am not saying that all the others, I have a view, all the other cases which have gone before death penalty, there can be a view about whether they deserve the death penalty or not. But I think the question for us today, as we live in this society, is a Kasab a person who deserves the death penalty? And if a Kasab is, then we must limit the death penalty to those kind of cases. You must take out, there are I think 11 sections in the IPC which provide for the death penalty. There is a serious debate as to whether you need the death penalty in all those 11 sections. But if you do, as a policy consideration, you certainly need to give, when you give the option of life, you recognize that it is not just about retribution, but implicit in giving the life is the recognition of deterrence, rehabilitation, and reformation. And if you recognize those principles of sentencing in the context of life, because it is only death which deals with retribution. Life, the principles of sentencing for life are deterrence, rehabilitation, and reformation. And you must recognize those principles and cannot take away the right of remission which is available in the law as it stands. Because there is still hope. There is still hope for that prisoner. Colin has given many of his own personal examples. There is still hope for a prisoner. You may provide, if you say policy considerations, 30 years, you may say 50 years, but there is still hope at the end of that period. And therefore, when you see a lot of, and 39A will have a lot of information on the doctrine of hope in death sentencing. That never give up that doctrine of hope if you say that there's an alternative to death, which is life. But if you believe that death penalty is the way, then don't have this other creation. Then let's hang him, and let not the state burden itself, as Aniket says, with all the costs of maintaining such a person, who in any case is not somebody who is valuable to society as determined by the courts. Then why give him the hope of life? In fact, giving him the hope of life itself is a violation of the human rights. So I think there is a need for, if ILS is seriously looking at this problem, then he needs to look at it at a policy level. I'm glad that Ms. Rastogi is here and she's heard some of my thoughts on the subject. I don't know whether they've already thought about this. Maybe they have, because they do. I've heard a lot about the kind of work that they do. I mean, the kind of analysis they've done on this subject, I don't think anybody really has done anything of the kind. But if there's anything that I can add to that thought process, I am not saying, let me put it this way, I'm not saying death penalty is to be eradicated. I'm saying death penalty, if at all, has to be extraordinarily limited. That's why I gave the example of a qasam. I don't know whether all such cases need to follow the same path. Therefore, I mean, with that, let me just end here. And thank you, Professor, for giving me the opportunity to share my own personal views on the subject with Project 39A sitting here. And because if your students evolve these, please tell them to study these two judgments, and they should be the ones preparing the paper on the analysis of these two judgments and everything that can be done. If you tell them to study the minority of Justice Lalit, where he has dealt with this issue, because the question is that if a Sessions Court can give death penalty, and why should he not be allowed to give death without life without remission? And that was the question. It was a question that was Justice Lalit put across. And then he ultimately comes to the conclusion to say that where is the power of the court? Under what provision of law does the court have the ability to create this new kind of sentence? I think it should be something that should be looked at and developed in some greater detail at the level of your cell and amongst the students, and then consider how to take this matter forward. Thank you, Professor, and sorry for pushing you a little bit with my WhatsApp messages, but we were running significantly out of time.
Thank you so much, sir. Thank you. It was wonderful listening to you, and many new points have been made in your talk here today. Apart from the traditional debate of abolition and retention, new philosophical and moral and human rights issues have been raised. If you are making a person to live whole of his life in prison, then it also amounts to violation of his few of his human rights, and this is a new dimension which you have given to this whole debate.
Professor, I call it another form of the death penalty.
Yeah, you made a point. It's hanged or death.
It's still the death penalty.
It's still a death penalty, and therefore you have another form of death penalty. Let a person die in prison till he dies. We can, and then Aniket's issue to come up about. Aniket, let me just first sum up in 2 minutes, and then we have questions and cross questionings coming up. Right?
Professor, I'm going to exit, but I'm going to make one provocative statement. In India, we have a third form of death penalty, which is known as the encounter. We've seen one yesterday, and that is also the death penalty.
I was expecting it in today's debate, sir. I was very much expecting it in today's debate.
Now, but yes,
that's the way of doing justice on the roads.
Yeah, it's justice on the roads.
But therefore, we need to find the right appropriate.
Yeah, but Aniket, we need justice. We don't need revenge. That is what the whole criminal justice is about.
That's true.
Yeah.
Any form of extrajudicial. Okay.
Fine. Aniket made a point, and few important issues which have been raised is about he made a point regarding how long you want a person to be served in on taxpayers' money in the prison, and then he said there are people who he made issue of Kasab and Nirbhaya's case, and do they really deserve to live in society? Well, that is also a moral stand, and then Colleen says that it also shows that how civilized a society you are. While leaving, Colleen made a point, and his point was that in case of rape cases, there should be a harshness of punishment. And therefore, I suppose if we gather from this that in Nirbhaya, the punishment was justified. That is how it goes to. If any harshness of punishment includes capital punishment, then if we take that statement, Shreya basically spoke about her. Yeah, Shreya, I'll come to you. Yeah, you all will have forum to speak. Okay. Yeah. She spoke about her project, and she also brought some actual statistics which comes up and which says that just going by what is rarest of rare would also be problematic if you see that the trial court judges do error in the judgment, and therefore you have a 30% of cases been acquittal comes in, and then how does this error happen? 29% cases do acquittal comes in, and I think we should look into the statistics also. And the most important point is about Desai sir, is argument raised by Desai sir, that how do you look at death sentence with this whole new idea coming up, saying that we want a person to die in prison, but we don't want to hang a person, but still And then the whole part is that you just take out the whole idea that a person could reform. It is said that where there is life, there is hope. The very famous statement which in money history which comes in. But if there is life, there is hope. So when a person is alive, there is also hope that he could reform. So does the society believe that a person will never reform, and therefore he doesn't need any type of corrections or reformations? So with this, I keep the forum open for discussion. Speakers could, if they have issues, can raise questions, clarifications, and rebuttals, and then after we'll take question answers.
I just wanted to comment on
Shreya, and then Aniket.
Yes, Shreya, please go ahead.
Yeah, no. I just want to. I just want to come in on the aspect of raising questions about like if someone who's been convicted for a terrible offense, and let's construct a hypothetical, right? That absolutely like everything is pointing in the direction of the guilt. You've got foolproof evidence, you've got CCTV, you've got DNA, you've got everything, much like Kasab, right? What is the point of keeping that person alive on taxpayers' money? Like, I just want to like put some reality behind this. Please, it's a bit disingenuous to say this when all of the data around the amount, and this, I mean, already in India, one thing that I think like all of us should agree on is that there is very little that people actually know about the way that the criminal justice system works, because there's very little which strong empirical research which has been done on it, right? And there are several extremely good organizations, many which have started much before Project 39A, and we're following in the footsteps of giants there. But all of that data shows to us that there is extremely little money which is given to prison infrastructure in this country, right? Very little money which is spent there as compared to the money which may be spent on several other things. Does anyone right now in India, does anyone have a figure on how much money is spent on one individual, on one death row prisoner, much like the stats which have been created in jurisdictions like the US? No one has done that research. No one has that. So can we please not make these false suggestions and lies that so much is spent on people, especially when in a case like Kasab, we know that the public prosecutor came on record after that to say that the narrative which was created about Kasab wanting mutton biryani and having that served was done only so that because public emotion was actually rising in his favor. I mean, these are not my words. This is reported. This is for everyone to see that this has happened. That the public prosecutor came on record, told the media that he had basically lied because he saw the public emotion go in a terrorist's favor and he did not want that. And that to me is like, I'm not making it just about Kasab, right? And I'm not making it just about this system. I'm trying to make a larger point that there is very little that we know. This is a system where you have these kind of corrupt practices happening, where you have a lot which gets decided based on not what's happening inside the courtroom, but what's happening outside the courtroom. That affects very much.
We got your point.
Let's not, like those would be things that we should remember before we say that might as well just hang this person, right? And also the larger point of, and I'm not even going there because I think there's much which has already been said and things which have been documented in our work about, let's look at the actual principles on which we're supposed to theoretically sentence people to death. I can talk theory as well. I can talk about 235(2) and 354(3) of CRPC and how little of that actually gets implemented. Again, another research, sorry, this is a different point, Nitish, but I'm going to continue my comment here. When we look at our research that the trial court sentencing research released this year in March 2020, where we looked at 3 states, Delhi, Maharashtra, Madhya Pradesh, for the last 15 years, we looked at how have the trial courts in these states sentenced people to death, right? Like we read all of their decisions and we looked at in those decisions, in how many of the cases were things like, as the law in Bachchan Singh says that life is the rule, death should be the exception. In how many cases has life imprisonment, where people are finally convicted to death sentence, how many cases did the judges actually look at life imprisonment? Would you believe it? 73% of the cases did not have a mention of life imprisonment, right? I mean, this is documented stuff. So So let's remember this before we make claims about that the system works very well and everything's hunky dory. Yeah.
Aniket, your response.
Yeah, I don't always
Quick comments,
understand, sir, why there is. Hello.
Yes. We can hear you.
Yeah, I don't understand why there is so much of affinity for people like Kasab, for perpetrators of Nirbhaya. I mean, these people are not saints. These people have committed the most gruesome crime that anybody can imagine. And then after they have committed the crime, they pretend to be good. They pretend to be nice while being behind bars, but they have committed the offense, which is the most brutal sort of offense. Afzal Guru, Yaqub Memon, killing hundreds of people, spraying bullets like anything else. And in fact, Mr. Collins said that when he had met Afzal Guru in the prison, and he seemed to be a good man. I mean, I don't understand. Did he meet Afzal Guru prior to committing the offense? Did he meet Afzal Guru when he was committing that offense? That was an attack on parliament. We have lost our policemen. We have lost our men in uniform. And then all of a sudden we start developing this affinity, love, affection for such kind of criminals. I don't understand. As a society, when the crime is brutal, shocking the collective conscience of every man of this country, sympathy in any form would be misplaced, because then it would shake the confidence of public in the administration of justice.
Yeah.
If we start showing sympathy to people like Kasab, Pakistan will keep on sending its terrorists to India to kill people. And people who are living in India would want to fight for the rights of those terrorists who kill people in India. And I don't agree with that proposition.
Fine.
Now coming to,
yes. You have a point to make.
yes. Now coming to what Mr. Desai had said, he compared Jessica Lal with Nirbhaya. Two are completely different cases. Jessica Lal was shot point blank. Nirbhaya was brutally gang raped, inhumanly gang raped. She succumbed to the injuries because of that offense on that lady. So the gravity of the offense, the inhumanity in that offense is nothing, or it is at another level. And this offense cannot be compared with that of Jessica Lal. That's a wrong comparison. In fact, in Shraddhanand's case, the Supreme Court had said that in that case, life sentence would mean till the end of life, because Supreme Court was of the opinion that it was a case which falls short of the rarest of rare category. And therefore, the Supreme Court felt that 14 years of imprisonment, which is what normally life in prison means, would not be sufficient and enough in that case. And therefore, they evolved this theory that life means life till he dies. But even in Shraddhanand's case, Supreme Court said that this was not the case according to the Supreme Court, which would qualify as rarest of rare.
Okay.
And therefore, Supreme Court had said that death cannot be awarded. I think we must retain the provisions of death sentence for extreme offenses. I am not saying death sentences should be handed out right, left, center. Only in extreme offenses, which will really show depravity, and the magnitude of crime is of such a horrendous nature that one cannot even imagine in wildest of their dreams. For only such offenses, we need to preserve the sentence of death. And we have got many filters. When a man is sentenced to death, there are many filters, many avenues that he has to really exhaust before he is actually executed.
Thank you, Aniket. Desai sir, you want to respond to this? Or do you want to make a comment? Then I'll take a few questions from the audience. If you want to comment. Yeah. I think fine. Aditi, you have questions from the audience for the speakers?
Yes, sir. We do
Yeah.
have questions. We have a question for Shreya ma'am, that what is a speaker wanted to, a participant wanted.
Aditi, you're not audible.
I think she's dropped out, Nitish.
I think. Yeah. Okay, she'll come
I'll
back.
just say the question actually instead.
Sorry, Deban?
Yes, sir. I'll just say the question for Shreya.
Yeah,
ma'am.
please say the question. Yeah.
So, ma'am, what is your view on deviating application of rarest of rare doctrine by the judiciary, and should it educate and aware itself about it, and avoid for incurium in limine dismissals?
Right. Yeah, so absolutely. I mean, I do agree that there is a lot of deviation from, like I was saying, from the theory of how death penalty sentencing should happen and the framework that has been created in Bachchan Singh about that. And what actually pans out, right? That certainly is the reality, and that's been it's there's only mounting evidence on for that we've been seeing. So, like some of the reports that I would recommend people to read is the Amnesty PUCL lethal lottery report, where they looked at the Supreme Court decisions on how has the court actually gone about looking at a death penalty case, right? And the way that they have applied the death, the rarest of rare doctrine. And ourselves, we have looked at the trial court decisions, and we found that kind of variance appear there as well. So, I mean, the trial court study that I was referring to, that study shows to us that even though the Supreme Court has said that aggravating and mitigating circumstances have to be looked at, that it cannot just be about how heinous the crime was, that we need to have a sense of who is the criminal, what is the background of the criminal, and therefore look at the mitigating circumstances to understand that. Despite this law having been laid down in 1980, been reiterated over and over and over again by High Court, by Supreme Court, we have found that in the last 15 years at the trial court level, right, in 42% of the cases in Delhi, 62% of the cases in Madhya Pradesh, and 47% of the cases in Maharashtra did not have any mention of any mitigating circumstances. Now, someone would argue that, but Shreya, this could mean that maybe there were no mitigating factors, right? But this is not a discussion like that. This is not a hypothetical to be made that maybe there is actually nothing redeeming about that person. What also has to be looked at in this scenario is how much did the system actually try to learn about this person? And I want to go back to why this is important, right? Because I'm not just saying this from some sense of sympathy, right? Like, I don't want to make this about like, why is there sympathy for criminals? Why are you going out of your way to find this out? No, it's not because I think they are saints. It's because I live in a rule of law society. It's because I choose to adhere by democratic principles, right? And that rule of law society requires me that before the state takes someone's life and another individual takes someone's life, there needs to be a difference. The state has to hold a different standard, follow a different procedure. And that procedure requires you to actually do all of this, right? So I would say that this is the way in which it things need to proceed. And you can certainly see, like, I agree with the proposition put out in the question that does the judiciary need to know more? Absolutely.
Yeah, we'll take one more question. We are about to close by 6, and it's 2 hours we have been discussing. We'll take one more question. Yeah, Aditi, is there any other question?
Yes. Yes, sir. So there is a question for Aniket, sir, that whether principal sentencing goal of Bachchan Singh, which was later vitiated by per incuriam decisions and the apex court admitted in Santosh Bayar and Khade and Sangeet case. So this is a question for him. How can any human be equipped to assess if another person has remorse? There is obviously an element of human error. How can one's life or death be decided by persons who are capable of error?
See, I'll answer this straight away. In Bariyar's case, in Khade's case, Supreme Court observed that the dictum, the law of Bachchan Singh, was not really followed by the earlier judgments. Because what Bachchan Singh said was that the court who has to award the sentence of death has to first draw a chart of aggravating circumstances and mitigating circumstances. And after drawing that chart, the court will have to see, the court will have to balance them out while deciding which sentence to inflict upon. In fact, we also have the provisions in law where prior to inflicting the sentence, an accused has to be heard on the point of sentence, where the accused can bring on record all the mitigating circumstances in his favor. Now, even in the case of Nirbhaya, the Supreme Court had heard the accused on the point of mitigating circumstances in favor of the accused, wherein the accused had pleaded, or rather had said, that they come from a poor background, they are economically backward, they are not well educated, that they are only the bread earners of their family, And then the Supreme Court said in the judgment of Nirbhaya that despite all these mitigating circumstances being in favor of the accused, the aggravating circumstances are so grave that they trump all the mitigating circumstances in this case. And therefore, even in that case, the Supreme Court considered the chart of aggravating, mitigating, and balanced the situation out. Now, when you say that there is a possibility of error, well, I do not disagree with that. But we also know that the institution of the institution of judiciary, which is fully and appropriately equipped with the necessary knowledge of law, experience, talent, and infrastructure to study the detailed parts of each case based on the legally accepted material and then apply the principles that are laid down in several judgments. In fact, what I think is important is that the lower judiciary, which really conducts the trials, must be well educated, must be well informed with all the judgments and all the developments that are happening in Supreme Court as far as the matters of death sentence are concerned. We do have Judicial Academy for all the trial court judges, and they need to be briefed, well informed about all this development in law so that they are well aware. Their discretion is judiciously exercised when they have to decide between life and death in a given set of circumstances in a given particular case.
Yeah. Thank you so much, Aniket. We had a very wonderful discussion today. And when Aniket strongly argued in favor of having capital punishment, and he also spoke about how it would create a deterrence in the minds of others. At the same point of time, we have a very interesting argument and factual argument coming up from Shreya, and she has questioned a basic thing that how does a criminal justice system work? If your criminal justice system is full of errors and flaws, then in that case, the outcome has to be problematic. And at the receiving end are the people who are the most deprived section of the society. One research should also be done that how many people are languishing in jail or on the death row who are coming from the most deprived section of society, and had they offered a very good lawyer, then in that case, what could have been the outcome of the trial court judgment? And therefore, if you have a society which has a lot of discrimination or a lot of we have people who are maximum people on marginalized section, in that case how the outcome would be. And therefore this point need to be taken into consideration when we decide about, and therefore life is not mathematics where it's always 1 + 1 = 2. There could be many more other proposition. And the most important point which came up today for today's discussion is Advocate Desai's intervention, and a very philosophical, moral and jurisprudential intervention in the new trend of Supreme Court and legislative trend, where we make a person die not by hanging but in prison. And therefore he had made up a very important issue. His title of his paper was To Hang or to Die, and you want to make a person die in any case. He had also asked us to do a research on Shraddhanand and Sriharan case, and definitely so we'll take up the issue and write up. What is the outcome of this discussion? If somebody asks me, I think some important takes away which are there, that how do you define the arrest of right? That is a 40 years old question. But again, if there's a reform which is coming up, what are those offenses which actually deserves a capital punishment? That was what the outcomes Desai sir and others who spoke about. That can we define this very clearly and in a proper legislative language to be defined it, not a very loose philosophical discussion which many times comes up in judgments, but a proper pinpointed conclusion we come with. In what cases do we actually can afford, as a civilized society, we can say that we can still give capital punishment. What are those cases? Considering all these circumstances which we have been speaking about. Second point, which from my point, I say that as in civilization, do we really need that sentence? Because do we in any case, for that matter, person was a hardened criminal and kasab and other part, but still, if I'm civilized, do I really want to punish him? And that is what my individual take would be. That why, as a society, if I'm civilized, I really want to punish him, or I don't want to punish him, and therefore it is not of his standard, it is my moral and civilized standards I want to talk about. And that is what other countries who are talking about abolition of capital punishment in toto. So there are always multiple dimensions and multiple views on these issues. This is an unending debate. I said initially when we started that it's an old Shakespearean dilemma of to be or not to be, to die or to live. And this we cannot conclude, but we have to come to some conclusion. I thank all the speakers for their scholarly and articulated inputs for in this debate, in this webinar. I thank all the audience for raising questions. There were many questions which are there in the chat box. You can just go through it, but we don't have that much of time. And I also thank my students of Criminal Cell for making this webinar available. A formal vote of thanks would be given by my student, but as an in charge of Criminal Cell, I should thank everyone here, at least my students officially. So thank you so much for coming here. And now may I request my student Vedvati to propose a formal vote of thanks, and with this we'll conclude our session. Thank you so much.
On behalf of ILS Law College Pune, I would like to thank all the speakers. So I'd like to thank Amit Desai sir, I would like to thank Aniket Nikam sir, I would like to thank Shreya Rastogi ma'am, and Colin Gonzalez sir for sparing time from your hectic schedules and enlightening us on this very important subject of capital punishment. I'm very sure that your varied perspectives and ideas about the subject will help each and every attendee in formulating their own unique rational perspective and idea on the subject. Yes, Amit sir, we will take up the research project. We are really inspired by that as well. I would also like to thank all the participants for actively participating throughout the course of this webinar. It really wouldn't have been the same without all of you. I would also like to thank SCC Online, Live Law and Law Officers for providing us with their e-portals for advertising and publicizing this event. Lastly, I would like to thank Nitish Lasagre sir for moderating today's session and for constantly supporting the endeavors of the Criminal Law Cell. On that note, I'd like to conclude today's webinar. I hope all of you stay safe amidst these uncertain times. Thank you very much.
Thank you.
Thank you.
Thank you so much.
Thank you.